Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 17th of March 2025, the state filed its response in opposition to the state's motion to strike the DP in this capital case regarding Autism Spectrum Disorder. And this filing indicates that the state of Idaho is coming by and through the Latah County prosecuting attorney and responding to the defense's motion to strike the DP on account of his alleged diagnosis of Autism Spectrum Disorder, and in parentheses it stated ASD in capital letters. Here the defendant argues that it would violate the Eighth Amendment's prohibition on cruel and unusual punishment to impose a sentence of capital punishment because he has ASD. His argument, according to the state of Idaho, fails for multiple independent reasons. It goes on to page 2 of this filing to say, for starters, defendant's argument contradicts both U.S. Supreme Court and Idaho Supreme Court precedent. This is prior rulings that the state of Idaho is alleging, ladies and gentlemen, on this topic. He's saying that it is opposite of what both the state of Idaho Supreme Court has ruled and the United States Supreme Court has ruled. Then, in the next sentence, top of page 2, it states here, the only, and italicized, mental disability that precludes the imposition of the DP is intellectual disability as defined in Atkins versus Virginia. This is a 2002 United States Supreme Court case, and Idaho Code Section 192515A as an apple. The state then says no other mental illness qualifies unless and until the U.S. Supreme Court or the Idaho Supreme Court holds differently, and citing here to State versus Dunlop. This is a Idaho Supreme Court case from 2013. Then the state continues, even setting that fatal flaw aside. And by saying fatal flaw, what the state appears to be alleging here is that, look, the defense is coming and asking for a ruling that contradicts both U.S. and Idaho Supreme Court precedent, and that the only way that such a disorder like ASD could qualify for precluding the DP was unless or until the United States Supreme Court or the Idaho Supreme Court finds differently. So even setting aside this fatal flaw, the state argues the defendant has failed to prove the requisite national consensus to support his claim. And then the state goes on to say a critical part of that consensus is the actions of state legislatures in addressing the punishment defendant now claims is prohibited under the Eighth Amendment, and that's of the United States Constitution. It then goes on at the bottom of page 2, first argument, Idaho law only prohibits the DP for a mentally disabled person only when the elements of Idaho Code 19, Section 2515A are proven, and the state alleges that the defendant has failed to do so. They raise other arguments throughout this filing, which you can read for yourself, as I always encourage that you do. If you go to the Idaho Cases of Judicial Interest website, go down to the Kohberger case, and then you'll find this filing. It is dated March 17th, 2025. In the end, the state is urging the court to deny this motion. We await the defense's reply in opposition to what the state has filed here, and when they do, we will, of course, let you know. Until next time, this is Kathy. Thank you so much for joining us here today.